This is Kopsky versus Murrubber Technologies, and each side will have 15 minutes. The appellant may reserve up to 5 minutes. So if you would just let me know if you want to reserve some time, I'd appreciate it.
Yes, I'd like to reserve 3 minutes.
Okay, we're ready to proceed. Sorry, we had some technology issues, so we're running behind today. So I apologize to all of you on behalf of the panel. Thank you.
May it please the court. Good morning. My name is Bradley LeBeouf. I'm the attorney for the plaintiff appellant, John Kopsky. There are 6 assignments of error in these 2 cases this morning. 4 of the assignments of error concern the summary judgment rulings by the trial court. The first assignment of error is that the trial court erred denying Kopsky's motion for summary judgment for Murrubber for breach of contract and erred granting Murrubber's motion for summary judgment on that claim. It's undisputed that the contract issue in this case was an oral agreement. Back in 1996, Kopsky entered into an oral agreement with Bedell Krause, whereby Bedell Krause would compensate Kopsky at the rate of 25 cents per pound for rubber that Bedell Krause calendared for delivery to Paratech Incorporated. In 2016, Bedell Krause was sold to the appellee Murrubber Technologies. At the time of that sale in 2016, there was a payable of $13,930 that was disclosed as due and owing to Kopsky at that time. That payable was eventually achieved in early 2017. Mr. Kopsky continued to receive payments from Murrubber after the acquisition and after the $13,930 was paid. The last payment that Mr. Kopsky received from Murrubber was in January of 2018. It's our position that those payments to Mr. Kopsky should continue at the same rate of 25 cents per pound for the calendared rubber. That was the same rate of compensation during the nearly 2 decades that Mr. Kopsky was paid by Bedell Krause. It's undisputed that the contract at issue here was an oral agreement. It's seldom that an oral agreement would have the exact words of offer and acceptance. To prove the terms of the existence of the contract, there are many factors: words, acts, conduct of the parties, circumstantial evidence, and even silence can be used to prove the existence in terms of a contract. Kopsky has proven the existence of a contract. There were 28 checks issued to Kopsky after the Murrubber acquisition of Bedell Krause. All those checks were signed by Anthony Murrubber, the head of Murrubber Technologies. There's nothing deceptive about Kopsky's billing. There's no pseudonym used by him. The debt was already disclosed at the time of the Bedell Krause acquisition. The payments continued at the same 25 cents per pound rate. The court erred granting summary judgment to Murrubber and denying Kopsky any damages. Second assignment of error concerned the trial court erred as a matter of law granting summary judgment to Murrubber based on the statute of frauds. Ohio's version of the statute of frauds in this matter is found at Ohio Revised Code 1335.05, wherein no action shall be brought whereby the charge to the defendant upon an agreement that is not to be performed within 1 year from the making thereof, unless the agreement is in writing and signed by the party to be charged. There are numerous exceptions to the statute of frauds writing requirement, including part performance and full performance. Kopsky performed fully his part of the agreement. He performed it within 1 year. There's nothing further for him to do. He supplied the formula that was used by Murrubber to calendar the rubber for delivery to Paratech. There's no evidence that the contract could not be performed within 1 year. There's no alleged contract terms that would prevent performance within 1 year. Mr. Kopsky completed his end of the bargain. There was nothing further for him to do. There is no evidence that the original agreement between Kopsky and Bedell Krause agreed to last longer than 1 year. It was indefinite.
Counsel, I'm trying to understand understand the argument, so let me just back up a minute if you don't care. In regard to this compound or formula or whatever it was, okay? So did he actually sell the right to the formula, or how did that work?
There was the agreement dates back to 2016, where Kopsky invented this rubber compound formula that was mixed by Polymerics, Cuyahoga Falls company. Polymerics mixed that Kopsky formula, and then it was then shipped to Bedell Krause for calendaring. Then that product, after it was calendared, then was shipped to Paratech Incorporated in Illinois, and Paratech would then use that calendared rubber to manufacture inflatable airbags.
I understand that. I guess what my question is, if I understand too, it was an oral contract, a handshake that everybody seems to agree. But you're saying it could have been performed within a year, and I'm trying to figure out how it could have been performed within a year, because it sounds like as long as they used that formula, that product, they were bound to pay him a certain fee. So if they didn't keep if they did keep using the product and didn't pay him, then wouldn't that be a breach of contract?
Yes, it would.
Okay. And so how could that be done in 1 year?
Well,
I mean, how do they never get done with their performance, do they? They owe him indefinitely.
that's correct. As long as Murrubber continues to use the JFK formulas and calendar that rubber for Paratech. However, Kopsky fully performed his part of the agreement. He supplied the formula, he supplied the customer. There's nothing further for him to do. So that full performance was done at that time.
So your argument is the contract was for the invention of the formula and the sharing of the formula. That was the agreement. And that he complied with that by providing them with the formula that they would be able to use.
Correct.
Okay.
But he didn't really have, I'm sorry, but he didn't really have control over who that they use this, right? Because they ended up still using it, even though he asked I can't think of the name of the manufacturer now, but he asked them, the Paratech, I guess, to stop using the formula, right?
No. Paratech needed that formula to manufacture its airbags. Murrubber was not the only company around that could process that rubber, calendar that rubber. There were other companies that could calendar that rubber for Paratech. Our third assignment of error involved the trial court's granting a summary judgment to Murrubber on its counterclaim by determining that because enforcement of the oral agreement was barred by the statute of frauds and allegedly governed by an express agreement, the equitable theory of unjust enrichment is not available. Count 2 of Kopsky's complaint also pled unjust enrichment. Even if a contract is barred by the statute of frauds, there's an equitable remedy of unjust enrichment. Kopsky has satisfied all elements of unjust enrichment. There were benefits conferred on the defendant by Kopsky. They used the JFK formulas. They used Paratech as a customer. Murrubber had knowledge of those benefits. The accounts payable was disclosed at the time of the acquisition. After the acquisition of Bedell Krause by Murrubber, there are 28 payments made to Kopsky, and Kopsky appeared on the premises. So he was no stranger to Murrubber after the acquisition. Retention of the benefits by defendant using the JFK formulas and continuing to use Paratech as a customer would be unjust. There's no evidence that Kopsky's use of the Kopsky formula was gratuitous. The two Ohio Supreme Court cases cited in our brief, Hummel versus Hummel, 1938 case, and even older Ohio Supreme Court case, Towsley versus Moore from 1876, both stand for the proposition that full performance of an oral contract allows recovery under unjust enrichment, even if the oral contract was barred by the statute of frauds.
Let me just ask you a question. in regard to the complaint here, the complaint didn't ask for any type of declaratory or injunctive action to prevent Murrubber from using the formula, right?
Correct.
Could your client have sued? I mean, I know you can sue, but wasn't that a possibility to stop them from using your client's formula?
Yes, that is a possible remedy, but there was no incentive for Murrubber to stop using the Kopsky formula. That's how they made money, by counting that rubber for the customer Paratech.
Right, but what I'm saying is, if they could be enjoined from using his formula, then obviously they would be losing money, like you just said, and they would have maybe a basis for compensating him. So I'm trying to figure out what all these theories are, because maybe I'm just missing something in regard to the use of the formula by Murrubber, and maybe the other side can enlighten me a little bit, maybe. But go ahead.
Yes, there were 2 counts in Kopsky's complaint: breach of contract and the alternative theory of unjust enrichment. It's our position that there was a breach of the oral agreement by Murrubber's continued use of the JFK formulated rubber compounds and selling that calendared rubber to Paratech. Our 4th assignment of error involved the trial court erred in not imposing successor liability for an unsatisfied debt that was owed to Kopsky. There's a debt of $13,930 that was disclosed at the time of the Bedell-Krause acquisition. It's our position that that acquisition was a de facto merger, even though there was no formal merger papers filed with the Ohio Secretary of State. Revised Code 1701.82A provides that all obligations belonging to or due to each constituent entity, all of which are vested in the surviving or new entity without further act or deed. The defendant purchased all assets and liabilities of Bedell-Krause. There are several issues of genuine issues of material fact here.
Counsel, and I hate to tell you, but you're already into your 3-minute rebuttal. Do you want to keep arguing, or do you want to save that 3 minutes completely?
Yeah, I'll continue arguing, Your Honor.
Thank you.
There are several issues of material fact that are in dispute here. One was that the court never determined whether there's a breach of contract, decided instead that the statute of frauds barred any enforcement. There's genuine issue of material fact whether the Kopsky agreement was a personal services contract. That term was not defined by the court. Personal services contract is not mentioned in the revised code 133505. It's a question of material fact whether or not there was a meeting of the minds that the contract would be continued at the 25 cents per pound rate after that September 1st, 2017 meeting between the plaintiff and Mr. Murrubber. It's a genuine question, material fact, whether the terms that Bedell-Krause acquisition expressly denied, assuming all current and future liabilities of Bedell-Krause. We had 2 assignments of error in appeal number 29984. The appellee did not file a response brief in that case. It's our position that the trial court erred in its calculation of prejudgment interest, using that the date for calculating prejudgment interest from the date of filing the counterclaim. It's our position there were multiple accrual dates, and the prejudgment interest accrues from the time of each payment or invoice, and that's in line with the Ohio Supreme Court case of Royal Electric Construction Corporation versus Ohio State. And the dissent in that case by Chief Justice Moore actually took the position of the trial court that the date of the counterclaim is the date for calculating prejudgment interest. It's our position that Kopsky should be compensated for the prejudgment interest for each invoice or the data material sheet that he should have been paid at that 25 cents per pound rate. We request that the trial court's summary judgment ruling be reversed and that the matter be remanded to the trial court for further proceedings. Thank you.
Thank you, counsel. You have 15 minutes.
Thank you, Your Honor.
Happily. Thank you.
It's Sean Maystal on behalf of Appellee Murrubber. At first, I would like to respond to both Judge Carr and Judge Tedosio's questions, and because there seems to be a little misunderstanding about the JFK compound. Paratech directs Polymetric, who manufactures the rubber using the Kopsky formula. The rubber is then sent to a third party, in this case, Bedell, Krause, and then Murrubber, for calendaring. There is nothing that Bedell, Krause, or Murrubber ever receives with regard to a formula, a proprietary formula in any way. There's nothing that Kopsky provides that requires Bedell, Krause, or Murrubber to do anything different for calendaring the rubber. So to answer both of your inquiries, Bedell, Krause, nor Murrubber received anything proprietary from Kopsky. The only thing Kopsky did, pursuant to this oral handshake agreement, was to suggest to Paratech, use Jim Bedell's company, Bedell Krause, to calendar the rubber. That's an oral agreement. While we believe that the statute of frauds, as the trial court held, completely bars the continuation of that agreement, we like to focus for the moment on the fact that there's no dispute that both parties, whatever the relationship was when Murrubber took over in 2017, they terminated any and all possible relationships in September 2017. There's no dispute in Ohio law that parties to any type of an agreement can walk away from that type of that agreement, and provided there's nothing in writing that says that they can't. Here we know there's no writing. So if we look to the time period and we look at all actions of all the parties in 2017, Murrubber, Mr. Muir, testified, sent an email, as well as had a meeting with Mr. Kopsky and said, "You're no longer permitted at this facility. We are not doing any business with you." That was the express testimony, both at the trial transcript during the counterclaim, as well as the deposition testimony. There's no dispute. Mr. Kopsky, in return, likewise told Paratech, who he had a consulting agreement with, is, "I no longer have any relationship with Murrubber or Bedell Krause. I want you to use Graphic Arts or another third party to do the calendaring of the rubber." So, and he was barred from the facility. There is no dispute on that. Mr. Kopsky testified not just in deposition, but also during the counterclaim portion of the trial court proceedings. There, what we have is all parties walked away. All parties were done. If this court were to hold that parties absent a written agreement were forever barred to each other, what would be the impact on any relationship in the business community, or what would be the relationship between employees? We're an employee at will state. We're a contract at will state. If the parties cannot walk away, then they're forever barred. They're forever required to do business with each other. And this kind of segues into the statute of frauds argument, because it's important here to look at what was Mr. Kopsky's belief. Mr. Kopsky believed that Bedell Krause and subsequently Murrubber were forever barred from dealing with Paratech. So the reason I related to the employee at will scenario is because contracts, non-compete contract law is also important, because you have a situation where Mr. Kopsky believes that based on that oral handshake agreement, Bedell Krause and his successor can no longer do any business with Paratech directly without paying him a fee.
Counsel, I'm going to interrupt you
Sure.
briefly, because we're talking about what everyone's belief was, and the court hones in on the September 1st meeting, and it's my understanding from appellant's brief that his understanding was that he was going to continue to be paid the 25 cent per amount. And in fact, he was paid that amount for some short period of time after that September 1st meeting. I guess the allegation is that there was some credibility determination by the court on summary judgment with respect to that September 1st meeting. Can you speak to that?
Absolutely, Judge Hensel. In fact, I thought I might have been too quick with what I was saying before, because I actually honed in on that issue. Because if you look at the period of time after September 1st, you have Muir barring Kopsky from the facility. He tells Mr. Kopsky, and this is after that meeting, he tells Mr. Kopsky, you are no longer to come to the facility, and hence I'm enforcing the fact that I terminated any relationship with you.
Well,
No,
counsel,
on
I did hear you say that, but it wasn't my understanding that Kopsky did he come to the facility on a regular basis?
He did, because
Okay.
actually at page 20, 124 of his deposition testimony, he even talks that he did quality control as well. So he would come to the facility, and so the barring of him from the facility is important. But let's also look at Mr. Kopsky's own actions, because Mr. Kopsky testified that after that meeting, he likewise said to his consulting, under his consulting agreement, Paratech, I'm no longer doing business with them. So use a third party. And he from that period of time, September 2017 into the future, he desires that Paratech use Graphic Arts, which is a competing company, to do the calendaring of the rubber. And therefore, he likewise has said, we're no longer gonna be involved with Murrubber in any fashion. So there was no credibility issue that the trial judge made a mistake in taking out of a jury's perspective. Instead, the court stated very unequivocally in its order is that all parties after that September meeting said, we're not doing business with each other. And that's why the termination case law, which is indisputable, coupled with those facts, which are indisputable, support the trial court's decision. But again, back to the statute of frauds argument, and we talked for a moment about the 10th District's decision, as well as this court's own decision in Fleck versus Hammer in 2017, or 2007, if I remember correctly, is where you have contracts involving third parties, and this under relationship only works if Paratech, who by the way, as opposing counsel agreed, had completely no restriction at all from determining who would receive the product to be calendared. Kopsky did not bar under his written agreement with Paratech to say only these certain people that I approve of can use it. Instead, Paratech could go to anybody it wanted. So you have a situation like in DOP, like in Sebring, like in Fleck, where you have a third party actually controlling what happens. And because of that third party controlling what happens, as the 10th District noted in Sebring, is you have a situation where if the third party doesn't utilize them, you don't have a termination within a year, because termination is not the issue. It's a destruction of the contract. And destruction of the contract is not something that, again, back to the termination issue, is not an issue that goes with the statute of frauds analysis, but instead it goes to the fact that there's no meeting of the minds that the contract would continue, and only upon subsequent acts which occur outside the 1 year or of an indefinite duration, therefore require the agreement to be reduced to writing. Because again, the whole purpose of the statute of frauds is particularly for facts like this. Here we only have Mr. Kopsky. Mr. Bedell passed away. We have nobody, in the Supreme Court, as well as all courts, in creating statute of frauds laws and then leading to legislature's enactment of them, the focus is to know exactly what occurred, not 20 years. 20 years later, you don't know what exactly was or what orally was discussed. If you don't reduce it to writing, it allows for fraud, possible perjuries to then be present throughout the court system, which is the necessity for these rules to begin with. And just to focus on the unjust enrichment since I'm not sure 100% how much time I have. Yes, there was a couple payments made back at the end of 2017, as late as 2018. There was a clerical mistake. As testified, the accounting did not know that the relationship had completely ceased. So the trial court awarded that anything that was paid after the September 2017 termination were mistaken payments and should be recouped. We believe that that is the proper perspective because, again, there's nothing, as I pointed out before when I was pointing out the issue to Judge Carr and Judge Tedosio regarding their question, is Bedell-Krause nor Murrubber received anything from Kopsky in way of a proprietary formula or anything to that effect. So they were not enriched in any way. They did not benefit in any way. So the only person enriched after September 2017 was Mr. Kopsky by receiving those payments, which we believe should be rescinded, and the trial court properly issued judgment on that. The final point about successor liability, I'll just touch on here. There is nothing in the record as to what the actual documents were with regard to the Murrubber Bedell-Krause transaction. Plaintiff did not put those in the record. I'm sorry, appellant did not put those in the record. It wasn't, I mean, there's testimony that it was not an asset purchase agreement, and therefore there was no there could not be a de facto merger, and there was obviously no statutory merger involved. And then the final point was Murrubber had absolutely no knowledge aside from a receivable that there was any Bedell-Krause handshake agreement when they went forward with the transaction. So we believe that this court has the basis under any of three different legal avenues to affirm summary judgment in this case and affirm the counterclaim award. We believe that aside from, unless there's any other questions, that's what we'd ask the court to do.
Thank you. Thank you. And the appellant has just maybe 30 seconds because you used up almost all of your rebuttal time.
Yes, with respect to the successor liability, there was testimony and deposition and as well as trial that the acquisition of Bedell-Krause by Murrubber included all assets and liabilities. That was clearly disclosed. With respect to the termination by Murrubber of the contract with Kopsky, that's how the damages have accrued. They've refused to pay Kopsky the 25 cents per pound for the calendared rubber, even though they continue to use it. And there was an affidavit filed shortly before the trial by Mr. Kopsky, where he indicated there was over $108,000 that was due and owing to him. That translates to over 400,000 pounds of calendared rubber that Murrubber has calendared using his formula that he has not been compensated for.
Okay, well, thank you. I'm sorry. Go ahead. You can say you sum up.
Consequently, we request that the trial court's summary judgment ruling be reversed and the matter remanded.
Thank you. Thank you both for your presentations to the court. The court will take the matter under advisement and issue a written opinion that will be sent to both sides, as well as we release our opinions electronically through the Supreme Court, so you can check there as well. Our next